Good morning and welcome to the FDA Tobacco Compliance Webinar. I'm Sean Lyons, Executive Director of the South Dakota Retailers Association. Our organization is one of 3 South Dakota organizations who are working together to sponsor today's program. Our thanks to the South Dakota Petroleum and Propane Marketers and the South Dakota Association of Cooperatives for co-hosting this webinar. Today's program will feature a presentation by Doug Anderson, President of the WeCard program. Doug was involved in the launch of WeCard some 17 years ago, helping it evolve from an in-store signage program to today's standard bearer of responsible retailing. As I'm sure many of you are aware, WeCard is known for serving as a resource for the retail industry, helping retailers know and understand state and federal law, and most importantly, how to comply with the legal requirements. WeCard has online training, in-store age calculation tools such as the WeCard calendar, along with a variety of educational tools available to both retail management and frontline employees. Just a couple of notes before we start. The phones of all the attendees are muted so that we won't be hearing background noises. This webinar is being recorded, and the recording and PowerPoint presentation will be available from the 3 participating organizations. You will also receive an email with a link to the recording. Finally, we will have a question and answer period at the conclusion of Doug's presentation. If you would like to ask a question, just go to the panel on the right side of your screen where it says type message here. Type your question, then click send. At the conclusion of Doug's presentation, I'll read the questions out loud and Doug will provide the answers. We are also fortunate to have Jason Evans, a Deputy Director with the South Dakota Department of Revenue, standing by to answer any questions you might have about South Dakota's tobacco laws. With that, again, welcome to the FDA Compliance Webinar. We'll now turn the presentation over to Doug Anderson of WeCard. Doug, good morning.
Good morning. Thank you, Sean. And thank you to all of the South Dakota State Associations for sponsoring this, and thank you to Jason for participating as well. From the big picture of today's discussion, we're going to look at FDA regulations and the current level of enforcement activity. We'll look at the warning letters and the civil money penalties, civil money penalty complaints that FDA has pursued against retailers who may have had violations, and then we'll look at recommendations for retailers. A quick disclaimer here, this service is provided by WeCard, and it may or may not provide some information where you need to dig deeper and get some legal advice. So ours is not intended to be legal advice or a complete representation of federal or state law or local law or even FDA regulations, but we think it'll be very helpful to you today. The South Dakota Retail Associations and WeCard are committed to a variety of things, including achieving full compliance with the Federal Tobacco Control Act and the FDA regulations, and most importantly, helping retailers understand their responsibilities and the legal compliance requirements, and most importantly, denying illegal sales, tobacco sales to minors. FDA's authority to regulate tobacco. That was granted in the year 2009. It became active in 2010. It grants authority for FDA to regulate the manufacture, the marketing, the distribution of tobacco products, all designed to protect public health and generally to reduce tobacco use by minors. Currently, FDA regulates cigarettes, including cigarette tobacco, smokeless tobacco, and roll-your-own tobacco. We'll discuss perhaps what's coming in terms of additional products later on today. And we will also look at FDA's authority and how they've gone about inspecting retailers' compliance checks down to retail stores. From a satellite view, here are some of the milestones, major actions undertaken by FDA. This is not a comprehensive list. This is a list that we put together that gives you sort of the flow from top to bottom noting the year and that things began. You'll see that it was established in 2009. Enforcement started in 2010. That was right around the fall of 2010. FDA issued draft guidance on what they determined to be an effective training program. We'll certainly discuss that later today. Inspections started. Warning letters were issued to any retailers where FDA determined that there were violations. That continues. That started in 2010. That continues today, and you can expect it to continue. Civil money penalties started in 2011, and they certainly continue today. And again, we'll discuss all of those in more detail. So what are the regulations? Let's take a closer look. Naturally, there is the prohibition on underage sales to those under 18 years old. There is what's called a carding requirement. In this case, age verification requirement, where those attempting to purchase those products that I mentioned who are under 27 years old need to be asked for ID, and that is an each and every time requirement. As an example, if I know you and you're a relative, and I know specifically what your age is, but you fall underneath that under 27-year-old requirement, I still need to card you. Even if you came in earlier in the morning and I've carded you and you come back in the afternoon again, I still need to card you. It's an each and every time requirement. Face-to-face transaction requirement. That's regarding selling cigarettes or smokeless only in a direct face-to-face exchange between you and your customer. There is an exception for those retailers who have a business where no one younger than 18 years of age is present or permitted on the services at any time. There are no single cigarette sales. Lucy's, Singles, they have a variety of street names. Those are not allowed, and specifically cigarette packages are not allowed to be opened and then sold in any number less than the quantity that they were designed to be sold at, which is less than 20 in terms of cigarettes. There are other restrictions. Prohibition on free samples of tobacco products. There are restrictions on promotional items, gifts and discounted items. There are restrictions, self-service displays. Those are, including vending machines, need to be removed from the store. Tobacco branded items, such as hats and T-shirts that have a particular tobacco brand image or logo on them, those too need to be removed. Those are restricted and not allowed anymore. Again, currently, here are the items on the left panel here of what is currently regulated. In the future, e-cigarettes seems to be on the radar of the FDA. They've indicated that they intend to develop regulations for electronic cigarettes. That's something to look for in the future. As you know, state laws can vary. And again, I'll let Jason specifically, any questions related to that on South Dakota's law, but here are some examples of the variety of the way state laws cover the various products, and you should certainly check with not only WeCard's state law summary, which is sort of a helpful condensed version of what's restricted in your state, and also what types of IDs are acceptable. But there's, please pose your questions, and I think Jason will be able to answer those. Let's look at enforcement of what's been going on. As you know, South Dakota currently, there has not been an announced contract with the FDA to conduct FDA compliance checks, but 37 states and the District of Columbia do have contracts, and 34 of those states are currently enforcing. And this is based upon data that the FDA posts online at their website. And on the right column there, where I list the 34 states and the activity, that's through July 31st. And this is cumulative, starting in 2010, going through the end of July. And you can see there are some states that perhaps have just started maybe Wisconsin, and there are others who have started much earlier, perhaps in 2010 and 2011. You can see the volume of their checks looking at Alabama or Mississippi. It lists the number of no violations. That's something that the FDA puts on their website. Somebody's been checked and no violations were observed, and that's put out there. They also list the warning letters that have been distributed. They also post the actual warning letter on the website. And then there are civil money penalties, and civil money penalties are for those stores who had previously been checked and received a warning letter. That means violations were observed. And FDA has guaranteed that they will go back and revisit those stores who received a warning letter for a follow-up compliance check. And if additional observations of violations are found, a civil money penalty is then pursued against that retailer. Taking those same sets of numbers and looking at them just from a year-to-year standpoint, here's a breakdown, and you'll see it started off in 210, and the volume is on pace, at least in 212, perhaps to more than double last year's set of activity. What are the penalties? This is in the Federal Tobacco Control Act. There's a set of penalties on the left side as to what the violations are. The penalties are listed in the middle column there. Currently, FDA is following this reduced schedule, and they will do so until they finalize and establish what their standards are, definition and or regulations that define what an approved training program is. And I'll go into this in more detail, but what I've circled here in red is what's currently going on in terms of FDA activity and what the penalties are for any violations. So let's look at the protocol and the type of compliance checks that FDA is conducting. Generally speaking, there's two types, and I've highlighted them here. One, it involves an underage attempted purchase of the restricted products. And there's also a determination and observation of whether or not only have they been carded and the ID has been verified against the minor's age, but whether or not there was a consummated sale or not. There are also advertising and labeling restrictions. Again, those examples of either a self-service display, the single cigarette sales, the promotional items with tobacco-branded products, all those things are looked for in that second type of a compliance check, the advertising and labeling restrictions. So how will you know whether or not you've passed or failed a compliance check? And I'm using the terms pass and fail because that's what we're all most familiar with. The FDA does not necessarily use those terms. In their case, they do not notify you if you have passed, but they do post, again, that listing on their website of no violations observed. And that's where you can check, and I'll provide you that website address where it's easy to look up your store or your set of stores and determine whether you're on that list. And if there was a list to be on, that's the one you would want to be on, no violations observed. If you fail, FDA will issue, at least currently right now, a warning letter. And that's typically, I think the practice has been that they will deliver it via a UPS delivery vehicle. Same goes for the civil money penalty complaint. In the follow-up compliance inspections, if there are observations of violations observed, that you'll get it probably again via UPS that document. And those are posted online. Here's an example of an FDA warning letter, and I've blacked out the identifying information of the retailer. And you'll notice, and it's not, I'm not necessarily designing this visual image for you to read, but you can see that it documents a variety of things, including, and I'm going to highlight here some of the specifics of the evidence that's presented, of when it occurred, and what the violation was. In this case, they show it's December 2, 2010. A package of cigarettes was sold to a minor, and that they did not verify and that they did not ask for ID and verify that the customer was under 27 years old. FDA has also recently added a time of day, such as 2 o'clock in the afternoon, type of information to the warning letter. That was in response to retail industry's request to put that in there so that they could better identify perhaps what shift somebody was working on, so that they could provide remediation to the staff that happened to have been working on that at that time. Again, these are posted on there. It's a serious document. It's a warning letter, but FDA does require you to respond in a short time frame, in this case 15 days. No additional notification is given. They will go out and follow up and conduct an additional compliance check to see how your store is functioning. So let's look at the civil money penalty complaint. And again, this is for a second or subsequent compliance check inspection, looking for potential violations. And if those are found, this type of document is sent out to the business establishment. In appearance and in language, it is litigation talk. It is what the legal community would call an adversarial proceeding. It documents a variety of things, including FDA's legal authority, history of any violations, such as a summary of the warning letter violations that were observed previously in the initial check. It also details any violations that were observed during the follow-up compliance inspection. And so if you'll note at the top there in number 9, the follow-up compliance check was actually 2 compliance checks on 2 different dates, September 8th and September 21st. And I'm going to highlight here the number of violations that were found in this case. And you'll see that in A, they sold to a minor. B, they failed to ask for identification for under 27. They had a vending machine in the facility. And D is indicating that they failed to bring all these items into compliance. And so cumulatively, those 4 violations plus the prior warning letter, the FDA calculates that this is now 5 violations. And if you'll recall that chart where I showed you the violation and the penalty schedule, in this particular case, it's a $5,000 penalty because it's 5 violations in a 36-month period. So how do you respond to a civil money penalty complaint? And there is a process, and FDA, it's a detailed process, and it's outlined in that civil money penalty document. Generally speaking, you have 30 days to respond. That's an absolute deadline. You need to either do one of 2 things: either pay the civil money penalty, and by the way, if you do nothing, that is the same as doing something, such as indicating that you will be paying. You should not do nothing. You need to act and do something, and the obvious recommendation is to answer the FDA. And you can request an extension, but you can't. It's not guaranteed that it will be automatically granted within that 30 days. So don't, just because you asked for an extension, let's say on the 28th day, you still need to officially answer by the 30th, because you don't know when the timing is of the extension request and whether or not you'll be granted. And I'm going to go over some examples of what you should say in your answer, but you need to do it on time. This information was pulled from an FDA webinar, and this is their recommendations on what you should include in your answer to the FDA. And I'm not going to go over each one here, but they're all, it's officially mapped out by the FDA in this case. If you look at the bottom there where it does request a settlement conference, that's probably a wise thing to do, to not only respond but indicate that, look, you want to discuss what's next, as opposed to just immediately jumping and considering paying the fine. You should probably indicate steps you're taking to remediate your staff, your store, advertising and labeling, if any of those were violations, whether or not you're retraining your people, communicating state and federal law, reinforcing the carding requirement, etc. The bottom line is you need to be proactive, and here's where I'm going to move into the series of recommendations. The FDA, the Tobacco Control Act, specifically mentions effective steps to prevent violations of the minimum age requirements. Adopting and enforcing a written policy against sales to minors. If you don't have a written policy, you should develop one. Later on, I'll show you how to acquire a template that We Card put together on what a written policy should include. That should be helpful to you. Please go get it, if for anything other than comparing it against your own or using it as a base with which to develop one. Informing your employees of all applicable laws. That includes state laws. FDA wants you to teach and train your people on state laws. Naturally, I'm sure many of you do, if not all of you, but it's something that the FDA also focuses on. And then they want to know what disciplinary sanctions for non-compliance are in terms of your employees. And of course, requiring your employees to verify age through the photographic identification or an electronic scanning device. But in summary, all of these can be defined as training and educating your employees. I think we'll all agree on that. The other recommendation is be prepared. On the right here, I've indicated this is a visual flow chart, and I'm not going to zoom in on it because it really is too large and extensive, but it's just illustrative of the complexity of the civil money penalty process, starting at the top of getting your first compliance inspection to either passing or failing it, getting a warning letter, getting a follow-up compliance check, perhaps settling with the FDA, perhaps going to court, perhaps presenting evidence of your training program. It goes on and on and on. It is complicated. It's something you need to be aware of, but you need to prepare now. And again, I want to reinforce why this webinar is so important, and Sean and his state association and the others that have sponsored this, it's really a terrific thing because you're doing it in advance of enforcement activity in your state, and you are ahead of the curve, and I think that's a good thing. One of the things that you should be aware of is when you perhaps, if you were in that unfortunate circumstance of having a violation and a civil money penalty pursued against you, you need to recognize that those settlement talks or an eventual hearing involves you, perhaps your legal counsel, and you presenting evidence, documented evidence, to demonstrate and show your good faith efforts in training and educating your staff. Having that, preparing and piecing that together and putting a system in place now is a smart thing to do. Well, let's look at what you can't do. And I bring this up because earlier I referenced the approved training program that the Federal Tobacco Control Act calls for, and that FDA is currently following in terms of whether or not a retailer has one for the fine and penalty schedule. I highlighted that in red for you, and that is the current reduced schedule. FDA is proceeding as if everyone had an approved training program. Currently, there is no such thing. The federal law contemplates that there would be an approved training program, and those would be standards developed by the FDA that provides for that reduced fine and penalty schedule. Currently, the current sort of communication coming out of the FDA is that they won't necessarily approve individual training programs such as We Card or as others. We're not quite sure where they'll go and what they'll do. We know that currently there's just draft guidance on what they believe an effective training program is. We speculate that one day in the future there will be a definition of an approved training program, but currently it doesn't exist. So the logical question is, well, how can you benefit from an approved training program today? You can't, but you can, and our recommendation is be informed. The only thing that's currently out there is this draft guidance that I've mentioned several times on a tobacco retailer training program. That was put out in July of 2010 by the FDA. It details extensively what they recommend. Speculation is that perhaps this draft guidance will be used as a foundation for the eventual approved training program. We believe you shouldn't wait. We believe you should act on that draft guidance and follow it to the best of your ability, because FDA is aggressively enforcing currently nationally over 91,000 compliance checks. Again, reference those year-by-year chart numbers that I shared with you. They are expected to move from the 37 state enforcement contracts and the District of Columbia upwards to all 50 states, in your case, including your state. And currently, as I've demonstrated, they are pursuing civil money penalties. So don't sit on the fence and wait. Our recommendation is move ahead and follow the draft guidance. WeCard has done it for you, and I'd like to share with you a big picture of what we've done and what we have available to assist you in that area. What I'm going to do is a side-by-side analysis to show you what's in the guidance. We took their guidance and we incorporated it into our online training. Years ago, you may recall, WeCard would offer instructor-led training sessions occasionally across the country, sometimes to the tune of 300 sessions a year. That has gone by the wayside as online training has surfaced and has become not only a more cost-effective way, but more of a 24-hour, 7-day-a-week availability, and it makes more sense. So we've done that. We have 3 courses: an employee training course, a refresher training course, and a manager's training course. We think that's available. We not only took the draft guidance from the FDA, but we looked at a lot of other guidance that the FDA has issued, and we found bits and pieces of what we think is relevant information, and we included that as well into our training program. So we think it's fairly comprehensive. On this page here, we've taken the high-level areas and categorized them into areas. Their draft guidance literally has management practices. They indicate the types of training courses, and then a curriculum. So they've defined training beyond just a curriculum and the type of courses. They've also included some management practices. And at the beginning there, you'll see there's that written company policy against sales to minors that you should have. These areas I've highlighted here, these are certainly within your control. This is not something that WeCard or another organization can develop and provide to you in turnkey fashion. I've highlighted those there because these are things you should look at and think about offering and adjusting internally in terms of your management practices. From what we offer in our training courses, I've highlighted here how we've handled those, and we've certainly included all of the curriculum. We offer 2 different courses. That refresher training is perfect for remedial training for those who need it, as well as those who on an annual basis need to get retrained. And our suggestion is first take the employee training course, which is more comprehensive, and then they can follow up 6 months to a year later and take the shorter refresher training course. Documentation is important, highlighted there at the top, because if you have to go before the FDA and discuss settlement, or before an administrative law judge, you're going to want documentation that who and when and how your people have been trained, and naturally keep those documents and or electronic files. Again, we've put together a written company sales template, policy template, and we think you ought to acquire that. Mystery shopping is something that we offer as well. There are other companies that promote and service this. It's common in your industry, but here it's detailed in their draft guidance, and we want you to be aware of it. Our training courses are available in the cloud, online, 24/7. We recognize a lot of stores either choose to or don't have direct to the internet access, but they do have a computer-based training system either on a PC workstation or an internal intranet or perhaps on a learning management system. So for that reason, we offer licensing of our course so that you can put it onto your computer system. And if you're interested, please reach out to us on that, and we can discuss, how to help you there. WeCart has other resources. Some of these are familiar to you. Some of these are perhaps new, whether or not it's the state law summary or state sign requirement or the unique visual minor license characteristics identifying underage licenses versus adult licenses. We also have a PDF summary of the FDA regulations and the Tobacco Control Act. We've got other documents that we call Get Your Store Ready for FDA Enforcement. These highlight some of the things I've already shared with you, but they break it down into something that's possibly distributable to your front line and your managers. And then we've also got a series of best practices, and what's interesting there is we've annotated which ones also match up with FDA's draft guidance for tobacco retailer training programs. In-store signage, there is no FDA requirement on signage that you must post, but this is our standard logo that's been out there for 17 years, and you find it on a lot of stores. Because of the new carding requirement, each and every time for under 27-year-old customers, we worked with a major chain who wanted to help communicate this to customers, and they've indicated, and it's in market, and this is available on our website for purchase. And they've indicated that this helps reduce the irritation factor for those customers who might be 25 years old and were carded the day before. It demonstrates that, look, the federal law requires this. Something for you to consider. You may know that we have other in-store signage. We also have some under 21 no alcohol messaging combined with the under 18 no tobacco. We recognize some stores have policies where they've upped it beyond the under 27 requirements, such as under 30, so those are available as well. If you have a smartphone, iPhone or other smartphone that can scan this QR code that's on the screen there, please do. This is a beta version of something we put together. You may find it helpful. It may be useful at headquarters. It may be useful for folks at the store level as well, but it's something that we've developed, and I'll leave it there just for another moment. We put together a summary of an FDA webinar that was very helpful on their review of the civil money penalty process. Some of the information from there I shared with you today. There's other information in here. This may be helpful to you. This was done just shy of a year ago. It was a good seminar, and we put this together. And if you'd like our summary, just email us and indicate "send me CMP summary" in the subject line, and we can shoot one out to you. But it does discuss some of this, and it may be helpful to you over the long haul. This is the website. This is a shortened version of it. You can find it at fda.gov, but this is where you can go to determine whether your store has been checked or not by the FDA and which list you surface on. It has a helpful decision type, which is either civil money penalty, no violations observed, or warning letters issued. And you can appear, over time, it's possible you may appear on all three, depending upon the volume of checks on your stores and how well your store has performed. There is a delay between when a compliance check was conducted by the FDA, when you're notified, and then when it appears online. Appearing online is there's somewhat of a significant delay, several months, but eventually it is on there. It's something, since they are delivering via UPS, you're going to want to make sure that your stores are aware of a potential delivery one day, and make sure that gets to your attention. You don't want it lost in the shuffle. We'd love to take some questions now. I think if you haven't had a chance to do so, please type them in on your control panel. There's a type message here. I think we've got a bunch now. Click send, and I think Sean's going to read them off, but I'll turn it over to you, Sean.
Great, Doug. Thanks for the very informative presentation. Just a reminder as well, we have Jason Evans from the Department of Revenue on the call as well, so if you have some state-specific questions, Jason would be happy to answer those as well. And I don't know, Jason, maybe this would even be a good opportunity for you to chime in real quick if there's anything that you wanted to add.
Yeah, thanks, Sean. And Doug, thanks for the presentation. That was very informative for us as well. I don't really have a lot to add from the state perspective. I certainly don't think the state has any requirements that are more restrictive than what the FDA has. I might just mention, though, the criminal penalties that the state imposes if there is a sale of tobacco products to an underage individual. That is a Class 2 misdemeanor in South Dakota, and a Class 2 misdemeanor is punishable by a maximum of 30 days in jail and a $500 fine and/or a $500 fine. So, in addition to all the civil stuff that the FDA may impose, there may also be some state criminal actions taken for sales to underage individuals as well. But certainly, from the state perspective, I don't think there's anything more restrictive than what Doug has presented here.
Well, let's get into some of the questions then that we received. And again, a reminder, if you have specific questions, please feel free to type those and send them in, and we'll get them right off here in the next few minutes. I'll start with a few questions that we've received. I have a store in a small town. My clerks know most of the customers by sight. Do they really have to card the same people over and over every time they come in, even though they know they're at least 18 years old? Doug?
Yes, and it's a good question. It's a common question. In the past, the answer may have been no, that you don't have to. Today, though, with the FDA requirement to card each and every time under 27-year-olds, the answer is yes, you need to. Familiar faces, relatives, they need to be carded each and every time.
How old does a clerk have to be to sell cigarettes and other tobacco products in South Dakota?
And I'll defer that one to Jason. On the federal level, there is not a particular requirement regarding age of the employee.
In South Dakota, there's no requirement either. So any age individual can sell tobacco products.
Do my clerks have to card people when they purchase cigarette lighters and the paper used for rolling cigarettes?
For the federal requirement, rolling papers, lighters, those are not covered. It is just the cigarettes, cigarette tobacco, smokeless tobacco, and roll your own tobacco. In the future, there may be e-cigarettes, there may be other products. Currently, there are not. So it's just that set. At the state level, I'll defer to Jason.
I'll just echo Doug's comments there. It's the same at the state level as well.
Very good. The FDA isn't currently doing compliance checks in South Dakota, but is this regulation in place here anyway? Do we have to card everyone under 27 even though they're not doing compliance checks?
My recommendation is yes. Enforcement, the opportunity, FDA's authority to enforce began in June of 2010. At that time, I'm recalling that the FDA indicated that they're going to go out and execute contracts with the states to then conduct compliance checks, and in the meantime, they may conduct enforcement using perhaps their own staff. To me, that's a heads up that you better follow the federal law that's been in place since then. So yes, that would be our recommendation, is to treat it as if it's currently being enforced.
And the last question that I have right now, and this will be one more reminder to folks, if you have a question, please submit it here in the next couple of minutes. Are electronic cigarettes included in this FDA regulation?
It's a good question. Currently, they are not. FDA has indicated they are looking at issuing a deeming regulation, and in other words, putting it underneath their authority. It has, latest I've looked, it has not happened yet, but I think it's logical to assume that that is something that's coming. So there's the current status of it. It's not yet, but it's logical to assume that it will be.
Another question here that just came in. So do our cashiers have to memorize every customer's age in order to know who is 27 and who isn't?
Another good question. The FDA indicates that customers under 27 need to be carded. It doesn't get into the nuance of your ability to properly guess or not. For that reason, some stores move their carding policy to a higher threshold, such as under 30. It's a difficult task to guess age, as you know, and that's why in our training, that's why we indicate that guessing whether or not somebody is old enough, such as 18 years old or not, is not the threshold. They need to look and size up their customer in terms of that under 27 threshold, and that's a big sort of mental difference between looking at someone and thinking whether they're old enough, 18 versus 27. Break yourself of that customer transaction observation and move the threshold to under 27, and literally practice at carding, and that's what our training handles, and we've got some other items that handle that as well. But role-playing internally between a manager and a frontline employee and sizing up customers, it really helps change the pattern from just thinking 18 and moving it to under 27.
Very good. Is Congress working on overturning this regulation, or does it look like it is here to stay?
I'm not aware of any congressional action to do anything different than what is currently there. You know, it's a fairly, in the scheme of things, it's fairly new. Last couple of years where it just started, so I wouldn't. I really can't speak to whether or not Congress is looking at that or not.
On the online training test with WeCard, is the test graded online at the time that they take the test, or does the store trainer do this?
It's graded online at the time of taking the test, and it's an end of training test, and so the trainee will know immediately.
Real quick, and if folks have any more questions, we'll give them a last call to send them in. It's a good program, the WeCard program, and we're proud to partner with it, and as well as I'm sure the other organizations are. And I guess just the real simple fact of the matter is more programs like this that take place from an educational standpoint really lessen, I guess you would say, the need for legislators and other lawmakers to maybe go more the opposite direction. So at least it shows that retailers are serious about doing something with regard to reducing sales of tobacco to minors. Got another question that just came in. What is the South Dakota law on sign requirements? Jason, I think this would be for you.
Yeah, I'm racking my brain now thinking of that, and Sean, that might be something I have to research and get back to you, and perhaps you can send the answer to the questionnaire. Is that a possibility?
Yep, you bet.
Okay, I'll do that. Thank you.
And it might even
Sean,
go ahead.
Yeah, Sean, I wanted to, separate from that question, I wanted to highlight regarding who is responsible for the FDA fine. When Jason mentioned the severe potential penalty at the state level, I believe that was directed toward possibly the employee involved in the transaction. For the FDA, the fines and penalties are directed toward the owner of the store, not the employee.
Do they come in to check the age with someone under 27 and someone under 18?
I'm not aware of the specific age range that the FDA is using during their under 27-year-old inspection. So it is, I believe, in fact, when they've been asked that question, they've indicated, you know, look, we're going to enforce the law under 27. So to me, that's an indicator that it's possible they may be using a legal of age purchaser, but who is underneath the carding requirement of under 27.
Very good. Doug, any closing comments or thoughts that maybe we haven't touched on or you want to highlight?
Well, I just want to reinforce that it's good to be proactive. Stay informed. You can go to our website. You can go to FDA's website. Over a period, you know, the FDA is still young in its authority and in enforcement in terms of gearing up. They haven't gone to all 50 states yet. You can bet that they will. The additional regulations may be forthcoming. Adjustments in how they're doing things may be forthcoming. This is what we currently know. This is our current set of recommendations on how to proceed. It is best to be proactive, and so there's our underlying message.
All right. Very good. Well, I appreciate Doug and Jason being on the line with us today. Doug Anderson of the LECART program and Jason Evans of the South Dakota Department of Revenue for answering questions about South Dakota's laws and the overall federal state of play. Again, a reminder that a recording of today's webinar and the PowerPoint presentation used for the presentation will be available through all three of the sponsoring organizations, South Dakota Retailers Association, South Dakota Petroleum and Propane Marketers, and the South Dakota Association of Cooperatives. Doug, Jason, we appreciate you taking time to join us today. And with that, thank you everyone for participating. We hope you have a great day.